Good day, everyone. This is Arugu Speaks on Arugu Insights. Today, we'll consider the basics of a valid contract under Nigerian law. A contract simply is an agreement between two or more people that a law will recognize and enforce. In Nigeria, for a contract to be valid, it must meet some basic conditions. If any of these conditions are missing, the contract may not be enforceable. By way of definition, what is a contract? A contract is an agreement that creates legal obligations, meaning that the people involved can be held responsible by law if they do not do what they promise. For example, if you agree to sell your phone to someone for 500,000 naira and both of you accept the terms, that is a contract. The elements of a valid contract, these essential elements of a valid contract. For a contract to be valid in Nigerian law, and where we got our laws from the United Kingdom, it must have these 6 things. 1, offer. An offer is when one person clearly states that they are willing to do or give. Example, I'll sell you my phone for 500,000 naira. The offer must be clear and communicated to the other person. Just showing interest or saying I might sell is not an offer. That's simple. What then is acceptance? The second element. Once an offer is made, it is incumbent on the other party to accept. Acceptance is when the other person agrees to the exact terms of the offer. For example, I agree to buy that your phone for 500,000 naira. Agreeing to the exact terms. If they change any part of the offer, it is not acceptance. It is a counter offer. Acceptance must be communicated. You cannot just stay silent and assume that an agreement has been reached. The third element, consideration. Once an offer is made and acceptance is taken, the third thing is consideration. What then in law is consideration? This means both sides must exchange something of value. It could be money, it could be a service rendered, or a promise that is made. For example, the buyer gives the 500,000 naira and the seller gives the phone. That is consideration. If one side gives something for nothing, it is usually not a valid contract unless it is a gift under a special legal form. Offer, acceptance, consideration. Then we move to the fourth element of a contract. The intention of the parties to create legal relations. Both sides must mean for the agreement to have legal consequences. In business deals, this is almost a given. It is assumed that both parties intend that the agreement will have legal consequences. But in family or social agreements, like between spouses or friends, it is usually not assumed unless stated clearly. As an example, I've made several promises to my wife that I've not kept. My wife cannot bring an action against me for breach of contract because promises exchanged between spouses are not intended to have legal consequences. I've made a lot of promises to my children that I have not kept. Promises that are made to children or family members are not normally intended to have legal consequences. That's the capacity of parties to contract. Not every man, not everyone can make a valid contract. For you to make a contract under Nigerian law, you must at least be 18 years of age. Minors can only make contracts for their basic needs. Lawyers will say for necessaries and for continuing obligation. And then you must be of sound mind. You know the craze. You know drink kai kai. You know smoke igbo, don't lose your mind. You are of sane mind. Your mind is sound. You know what you are doing. And then you must have legal authority. You cannot sell what is not your own. For example, a company must act within the powers given to it by the articles and the memorandum of the company. And then, the last one, free and real consent. For the contract to be valid, everyone must agree freely, not because of lies, pressure, or tricks. If one person was forced or deceived or made a mistake about something important, the contract may be invalid. The elements of a contract are just what we have discussed in very simplistic form. The types of contracts that we have in Nigeria. Contracts can take different forms in Nigeria. Written contracts, everything is put in writing and signed, like a job or house agreement. Your tenancy agreement in Nigeria must always be in writing. And then oral contracts agreed through spoken words, valid but harder to prove. That's why if you go into business, it is safer to distill what has been agreed into writing. Implied contracts formed through actions or behaviors, even without words, like paying for food at a restaurant. All of that. Why do these rules matter? These rules help us to ensure fairness and trust. They protect people from being cheated or forced into bad deals. Nigerian court use these principles along with examples from English law to decide if a contract is valid or not. By way of concluding, I would say that a valid contract in Nigeria must have an offer, an acceptance, consideration, intention to create legal relations, capacity of the parties to contract, and then the reality of consent, or what in ordinary parlance you can call free consent. If any of these are missing, the contract may not stand in a court of law. You can take this home.